All right.
Awesome.
Let me just jump in or
Good to go?
Yep.
Okay.
any prompts?
No,
Okay.
you just start. Yeah.
All right.
And they'll cut it up.
All right.
Oh, yeah.
Yeah.
So I could start with I was born in Orange County.
Let me start by introducing you first.
Why?
Right?
Why would they need to know my name? That's what I said. All right.
Because they have no frame of reference for
They
who
don't
you
need
are.
to know my name.
This is gold. We're going to keep all of this
This
in.
is- yeah, these are bloopers, outtakes.
These are intakes. These
Yeah.
are just good.
All right. We're back with another episode of the It's Personal podcast. I'm Christopher Adamson.
This is personal injury. It is personal.
Today we're joined by Austin Ward, a partner in our firm. He's here to talk about fee caps in personal injury cases specifically because that's what we do. It's a subject that's kind of near and dear to our hearts. The topic will get a little broader as well, and then we'll kind of pare down to how it affects individuals' access to justice, et cetera, things like that. But first, before we start, Austin, just want to give everybody a little bit of background about you, how you got into law, how you got to our firm. So why don't you dig into that a little bit?
I got into law.
Yeah.
Okay. So I grew up in Orange County. Anybody who practices PI law understands the different counties have different bends. Some more conservative, some more liberal. Orange County is universally understood as being one of the most conservative venues to have a case. That was the environment that I grew up in. Both my parents, very conservative. And I grew up with a certain idea about personal injury lawyers. And that idea was they're disgusting and despicable. And even when I was in law school, I didn't know what I wanted to do. I looked at all these different areas of law that I might go into. I didn't know what I wanted to do, but I did know one thing. I was not going to be an LA personal injury lawyer. That was the one thing I knew, which obviously did not hold.
But at that time, how do you think you even developed that kind of
Impression.
impression as to personal injury attorneys or LA personal injury attorneys?
Well, a big part of that, I think, was, the conservative ethic is a lot of personal responsibility, a lot of, bad things happen in life. You don't dwell on it. You do you respond, you get yourself back up, and you don't whine, complain, or make excuses, which I still believe in. That's still a very important thing I teach my kids as well. But part of that mentality, I think, makes it very difficult to understand how you can put a monetary value to intangible things like pain, suffering, emotional distress, and especially when you're dealing with negligence. It'd be one thing if you're talking about sexual assaults. It'd be one thing if you're talking about battery. But everyone makes mistakes, and to say that this person needs to pay millions of dollars because you can't get your emotions in order. The default presumption for me and for my family and a lot of my community was, that's a you problem. That's not a them problem. And you're just asking for money that seems, I don't understand that. Frankly, even as a first-year lawyer in one of the biggest PI firms in the area, I still didn't really understand it. I remember the first trial I ever did as a baby lawyer. In fact, I had just been admitted to the bar like 4 days prior, and now I'm going down to Orange County, back to my hometown for this trial, the wrongful death case. And the senior attorney trial lawyer, who's phenomenal, she came over to me after her opening statement, and she asked me for my thoughts on, okay, so if you're a juror, because I'm in Orange County, I was like, perfect. Like, how much would you give at this point? And I'm like, well, we haven't seen any evidence yet. I need to see the evidence. She said, no, but like, what would you be feeling right now?
Yeah.
And I thought, I guess if I had to give a number, I'd be around, here. I gave a number, I think it was like 200,000. Her jaw drops. She looks at me like I'm the enemy.
Yeah.
And she straights up, you are a defense lawyer. I can't believe this. We lose, Austin. If that's what it is, we lose. She lost, and then we ended up doing, a heck of a lot better than that. And I just had a hard time understanding general damages and the purpose of it and how. So anyway, that was kind of the bias that I had growing up.
If you had that bent growing up,
Yeah.
how did you end up at a personal injury firm?
All right. So while I'm in law school, I'm doing this thing called mock trial. Mock trial is, you might think of it like sports for lawyers. They create a fact pattern that you then try to litigate and compete against other schools.
It's like debate, but like in essentially a fake trial.
A fake trial, yeah, exactly. you get a fake fact pattern, you put up witnesses, and then you inquire, object, argue, closing arguments, the whole thing. And then you're scored by other lawyers in the jury pool. And I was very good at it. I'd done that through high school as well. So while I'm doing that, one of the colleagues was interning at that firm, and they asked him to work. He couldn't, so he referred me. It also so happened that one of those lawyers that was scoring me during one of these competitions happened to be the brother of one of the top lawyers at that firm. Okay. He independently just talked about my name without me knowing him. Or he's like, there was this guy, his name is Austin. It was at Pepperdine. And so between this law clerk who was my friend, this guy who was just in the jury pool for my mock trial competition, and then for one of my professors, everyone was talking with this one guy about me and telling me, you should look into this firm. It's a trial firm. And I thought, I want to do trials. That's what I'm good at. And this firm does that. And they have a reputation that was very high caliber. And so my concern about working on cases that might have been frivolous, what my biases were, if I don't want to deal with frivolous cases, that was allayed by the fact that this firm got to pick from the best cases. I wouldn't have to worry about that as much. So I'm going to do trials, and I'm getting, merit cases. Okay, so let me learn. And so I went there and, didn't sleep for a couple of years and, and worked on that. And during my time there, though, I mean, my eyes were opened to how things are working behind the scenes. And
in what sense?
So multiple different angles. Okay. The biggest one for me was the realization, and perhaps there's a lot of naivety that went into that, but the realization that the real defendant is the insurance company. I didn't appreciate that in my soul. I thought, oh, you're going up against this other person. And this poor person who has a mortgage, has a family to raise, you're asking for millions of dollars from them. Like, that can't be right.
That's what most people think.
That's what most people think. And I think it's criminal that in trial we can't tell the jury that.
I agree. We're biased being plaintiffs' attorneys, but I agree.
But
100%.
it's the truth. And the reason why it's important is because if jurors knew the truth, there would be less hesitance in awarding the right number.
Right.
If you think, hey, this is the right number that's fair, but I don't want to hurt this individual, I might take it down a little bit. That's not truly what's happening. And so it's the deception that causes the problem in any event. So I began to realize that. And then realizing the insurance company is the defendant, I didn't have a real strong bias against insurance companies. Again, super conservative environment. Like, hey, it's a business. They've got this. But then I started to see how they act. And I started to see case after case after case of a 70-year-old woman who needed 15 surgeries. Her life was turned upside down. And they're denying the most obvious stuff imaginable. No liability. We have stacks of evidence of liability. Liability is not even an issue in my mind. Denied. How much are you willing to offer? No offer. $5,000. The audacity of the greed. It knew no bounds.
So I was going to ask, why do you think that is? Do you think it's solely greed? These denials and zero offers.
Yeah. Well,
and
so why? That's a big question.
I know.
I think greed handles a lot of it. But I do think there are other dynamics that contribute to it. I do think that there are a lot of plaintiffs' firms that are willing to exploit the inconvenience of having to defend cases. That's disgusting. And that hurts us. When firms do that, that hurts legitimate cases in the same way that if, you have this influx of people calling their animals emotional support animals to get them on planes. When people actually need their animal for diabetes, whatever, it hurts the credibility for what they actually need when you have all that fraud. And I think that there's an element of that does go on where they see all of these claims coming through and so much of it can be BS, that a cynicism hardens. And that cynicism, I think, can cause them to say, you know what, we're going to do everything we can to just say no and force them to prove their case. And that's just how it's going to be. Now, I think it's still unethical. We talk about, you hear frivolous cases a lot. You don't always hear about frivolous defenses. But if you read the rules of ethics in the California State Bar and in the ABA, you can't assert frivolous claims or defenses. It's an ethical violation. But I think that sometimes in our culture, there's this belief that because we hear criminal defendants have the privilege against self-incrimination.
Mm-hmm.
And in criminal cases, it's perfectly ethical and acceptable to sit back, shut up, let the prosecution prove their case,
Mm-hmm.
deny everything. This is your burden. That makes sense in a criminal context. And I think because we see that, we also attribute that same ethic or norm in the civil context where it should not be. Civil cases, the parties are equal, and you have a duty, both of you, to be candid. You have a duty to be honest. I understand that, you can tell the truth in different ways.
Mm-hmm.
Fair enough. But you can't lie. You can't frivolously say, no, we're not at fault. But it happens. And personally, I think that's a huge contributor to the high number of cases. Whenever there's too many lawsuits. Yeah, there are. If only they would just admit that they messed up and paid and did the right thing at the outset,
Mm-hmm.
we'd be out of a job.
Well, do you also think some or a lot of the vilification of plaintiffs' attorneys has to do with tort reform?
Well, of course. Yeah, that's a big part of it too.
Because I don't think people come by these ideas like in a vacuum. Like you could grow up in a conservative household,
right,
and have certain conservative beliefs, but with plaintiffs' attorneys specifically, because they get vilified a lot,
yeah,
right? And a lot of this had to do with tort reform in a lot of states that happened in the 70s. So tort reform just essentially means personal injury law for the viewers who don't know. So in the 70s, right, and like I think you probably know more about this than I do, but there were doctors who were getting sued. They were complaining that because of these malpractice lawsuits, their premiums were going up. These plaintiffs' attorneys are getting rich. They're like casting all these plaintiffs' attorneys like, Harvey Specter on suits, just like riding around in Ferraris, making all this money. And then something like that like anecdotally sounds true. It's easy for lobbying groups or whomever to come in and make that argument. And the average person, they're like, oh, that makes sense. So like in the 70s, a lot of these campaigns started nationwide, and then it now led to these ideas about plaintiffs' attorneys, I think, kind of getting baked into a lot of the populace, especially like the older populace, maybe not so much the younger populace. But my take is also that a lot of how people feel, like people the average juror wouldn't just come up with the term frivolous lawsuit. I don't think that's a term that's like, it's like planted in your brain, like Inception.
Right.
And then people just say it. They don't even know where they heard it. And now if a defense attorney comes in and says, do you think there are too many frivolous lawsuits? They're just like, yeah, I do. Yeah. And they don't even really know where that idea has come from because they haven't critically thought about it. It's just now ingrained in their brain. So, I mean, that's kind of my take on like the vilification of PI attorneys, how we've gotten to this point. Like, how do you feel? Or is there more about that you want to say?
I could talk about that for days. Yeah. So I could talk about that for days. Propaganda is obviously a giant part of this. So there was this desire for tort reform in a variety of areas. And the whole purpose of the tort reform is just to make it harder for individuals to seek justice. That's it. That's the strategy. I'll make it harder for people who don't have millions of dollars to spend to get justice. And this might be a good way we should come back to that because that's really at the heart of this whole like capping of contingency fees. But to provide some context for like people who don't understand what happens behind the scenes, because for me, I came in, I was like, why do they keep denying every allegation in our complaint? So the way that you start a lawsuit is you file a complaint, as you know. You file a complaint. The complaint sets forth the allegations. Those allegations are numbered in different paragraphs. You identify the cause of action. And maybe there's 100 allegations, 100 lines that compose the lawsuit. The defense then has 30 days to respond with what's called an answer. The answer is supposed to either deny or admit those allegations. Now, they can do a general denial as to everything, or they can admit the allegations that are actually true. About 10 years now in practicing law, not once, not one time have I ever seen any defendant in any case represented by an insurance company admit a single allegation to any allegation I make in any complaint. Not one. there's an administrative obligation if you're going to sue a government entity.
Mm-hmm.
Within 6 months of the incident, you have to file a government claim to give them an opportunity to evaluate the claim, which I'm sure they do, right? They really look at it and say, if we're liable, we should admit this.
Yeah.
Never once in my entire career have I ever seen a government entity admit and accept responsibility in one of those government claims. Interesting how normalized it is to say, no, deny, which pissed off my conservative sense of personal responsibility.
Yeah.
And to me, the responsibility is greater with those who have more power.
Well, I mean, also to that point in talking about responsibility and like those in power having more responsibility with respect to government claims. So just to back up, in a normal personal injury case, there's a 2-year statute of limitations. So when something happens, typically you have 2 years to file your claim, like let's say it's an auto v. auto claim or something like that. When it comes to government entities, you have this additional hurdle before filing suit that within 6 months from the date of loss, you have to file a specific government claim with the right agency. And if you don't file with the right agency and the 6 months runs, and then you find out afterwards that you filed it with the wrong entity, you really have no recourse. So when it comes to government entities, there's like an extra hurdle they make you clear in order to hold a government entity responsible that doesn't even exist for like private individuals, private corporations, et cetera. And to me, the whole purpose is because the government wants to skirt liability or skirt responsibility for things they are responsible for. So you have to, within 6 months, and like the average person doesn't even know that. So if something happened and it was severe enough that you didn't even contact an attorney until 7 or 8 months later, now you've lost out on that claim because you didn't file the claim form within 6 months.
Can you give an example of what
Yes.
a government
Yes.
thing would be?
So all right. It's even worse than what you
Oh, no.
It's even worse. So like this is something else that people need to understand. So what I just said, there's administrative hurdle of filing the government claim. Well, what's the reason for that they give? What was the reason? The reason is this gives the government entity an opportunity to review the claim and to try to avoid costly litigation by acknowledging and resolving it early. That's the reason they give. Have you ever seen a government entity accept the government claim?
I've seen them accept a claim, but that doesn't mean that they're going to pay full value for the claim or evaluate it the same way I think once I've seen them accept a claim, but we still had to file and litigate, et cetera. It's not like they just accepted the claim, then say, what is this claim worth? Okay, here's the money.
Right. But so in terms of just liability, admitting liability, you've seen that happen before?
I mean, I've seen them accept a claim. I don't know that they accepted liability, but they didn't reject a claim, right? Because normally they can accept or reject a claim.
So even, accepting it. So to accept and admit liability, I've never seen it happen ever. The reason that it exists is to basically create this hurdle that they can then use to reduce X percent of government claims, of claims against that entity, which I know happens because I was talking with county counsel for one of the counties that I was suing. He told me that they send out these letters of, hey, you messed up, you missed the deadline every week. Every week they're sending out a new one to multiple different attorneys. It's happening constantly. So there's some percentage of cases where people are getting hurt, the government's responsible, and there's no justice for them. They're just screwed because they didn't know they had to file something within 6 months. And there is a mechanism if you're late, and especially if you haven't hired a lawyer yet, that the lawyer can then file a motion to try to secretly, and that's within the discretion of the court. They don't have to grant it. The court happens to be a public employee as well, might have some, budgetary concerns, but nonetheless, in their discretion to grant that relief, unless you made the mistake of typing in, hey, what's my statute of limitations on my personal injury claim? Google pops up and tells you 2 years, doesn't tell you anything about the government claim. So you think I've got 2 years. You wait for that first year to pass, get a lawyer. Oh man, you've waited a year. There's no motion that can be brought. There's nothing that can be done. You're out of luck because after 1 year, the court loses jurisdiction to be able to. So in a government claim, there's all of these very strict administrative requirements. Now, let's say that you wanted to do this. Okay, so I got to file my government claim.
With the right entity.
This is what I was going to say. So sometimes you'll have a government entity that has a sub entity beneath it. Like a county might be the correct entity for a school district,
Okay.
right? The school district might fall directly under that county. For a different county, the school district might be its own public entity. In another, and so like, for example, there was a case I had in San Bernardino where there's the county of San Bernardino, the city of San Bernardino, and then there was this reference to the housing authority for the county of San Bernardino. Often, the housing authorities are just a function of the county, but not in San Bernardino. It's its own public entity. How would we know this? Well, maybe you just type it in Google, right? You just do some research online. You could pull it. Sure, it's a public entity. It should be publicly available. No, incorrect. There is a list, an entire register of all the public entities that exists, but it's nowhere online. The only way to access it, I kid you not, is to find a magic phone number. You call this phone number, which is not readily available, and you get a hold of somebody and you tell them the name of the entity you want to check if it's a public entity. They go back into a room, and whether I think it's microfiche is what they told me. Like physical microfiche
Do you know what
files.
microfiche is?
No.
Okay.
Yeah.
She doesn't know what microfiche is.
It's a method of
It's like
data
slides.
preservation. Yeah.
It's the tiny
those
microscope
old
thingy.
slides.
Yeah.
Yeah.
Like old school libraries.
Exactly.
And then
Nice.
this person will go back, they'll look for that entity, and then they'll come back and they'll just tell you one way or the other. That's how you find out if this thing is its own public entity or something else, and you have no idea. So the types of claims this would arise in is, first, if it's an employee of a government entity who has, for instance, they're driving a company or a county car, they collide into you and they're negligent. Well, then you can have negligence on the public entity when they're acting within the course and scope. So that's one way you can have a case against a public entity. Another one is a premises liability, which is a dangerous condition of public property. And
Like if you get hurt at a public park.
Correct.
yeah, exactly. So, for example, a recent case, there's this beach down in San Luis Obispo. There's a sidewalk. The sidewalk was in a dilapidated condition and it was kind of hidden and obscured in certain ways. Client trips over it and has lots of injuries as a result. Who owns that sidewalk? How are you supposed to know? And so if you, for example, do a claim to the city thinking, hey, the city's responsible, so I'll satisfy my obligation, city of San Luis Obispo, you got the wrong entity. And so then you say, okay, well then who is the right entity? So now you got to hire, an expert.
Do they come back? Does like San Luis Obispo go, no, we're not the right entity? Like how long does that take that builds up all that
Depends.
time until the 6
There's
months are
no
over?
obligation.
Yeah.
For them to tell you we are not the right
Correct.
entity.
And so what has happened in the past, and this happens, is you can say, okay, I'm going to cover all my bases. I'm going to do the city of San Luis Obispo. I'm going to do the county of San Luis Obispo. I'm going to do the state of California. I'm just going to do claims to all of them. And so you do that, and then time proceeds, and you're trying to do discovery, and they're kind of stalling on discovery. They're being vague and ambiguous. And then after a year passes, they say, oh, by the way, this is not us, none of us. It's this other public entity. And now you're too late because the year passed, and now you're out of luck. All of this is designed to make it hard to actually see. It's now these are public entities, which has nothing to do with the insurance companies, but it just shows like these are strategies that whether it's in that context or in a private context, how do we try to reduce? We got to figure out ways to make it harder for people to get access to justice.
Which is, I think, is especially egregious because these are government entities who are denying their own constituents access to justice. And then, just so the people know, super producer Lauren Henning on the side, that's who we're talking to.
So what, okay, just to walk it back, what is the way, because you both said earlier, like, if all went well, we wouldn't have jobs. What is the way that it is supposed to happen, whether it's the government or an insurance company, right? Because you're paying taxes towards your city, towards your government, you're paying premiums towards your insurance company. Like, what is the way that should something happen, it should go down?
Well, in an ideal society, you have, people who are able to take responsibility for their own actions and make other people whole, right? Like that. So ideally, you don't need any involvement or intervention from the government, right? So this is people do this all the time when you're just dealing with like ordinary people. Somebody gets hurt. I messed up. Hey, I'm so sorry. What can I do to help you? then there's no need to resolve the dispute because you have people taking responsibility. Sometimes there's good faith disputes. And if there's a good faith dispute, then we have a public system of justice to resolve those disputes. And that's the whole purpose of the law in this context. Then within that context, there's different ways you can approach it. You can approach it with a sense of professionalism and civility and good faith, or you can approach it from a position of, this is a pure competition, zero-sum game, screw you, and I'm going to do everything I possibly can, and wherever the line is, I'm going to push against that. Those are two different approaches to that system, and I think the more you have that latter approach, the more it degrades the quality of the entire system. And so the reason I raise that example of answers to the complaint is, when I was starting out as a lawyer, I was trying to be very earnest about, okay, this is what is true. This is what we're disputing, and just kind of getting it piece by piece and expecting in turn, when I file a complaint, hey, they're going to admit the allegations that are obvious and just dispute the ones that they have a good faith, reason to dispute. And then that narrows the case and narrows the facts. We can just focus on the issues of dispute, and we can both of us save money and time and effort and just really focus on those disputes. That's not how it works, right? The way it works is we deny everything. F you, good luck. And we're going to deny you everything we possibly can. And that creates all kinds of burdens on the system.
I would add one caveat, I guess, to your question, because your question is kind of like, in an ideal society, how would things work? But in an ideal society, there would also be an infinite amount of money available to compensate somebody for the wrong he or she has suffered. Right. So we've had cases where it might be a death case, like an auto case where somebody passes away, there's no insurance, or it's a minimum policy. So in those cases, there's not enough money available to compensate somebody, obviously, for the loss of a family member. Or let's say somebody's even like egregiously injured in an auto collision, but there's still a minimum policy. There's not enough insurance to go around to compensate somebody for their injury. So I think in some ways, ideally, there would be a lot of comedy in the profession, not comedy like jokes, but comedy like people working together, right? To Austin's point, like we would be able to zealously advocate on behalf of both of our clients, but do it respectfully. So that's one aspect of it. But in terms of the damages aspect, like ideally that might not be achievable because in some cases there's not going to be enough money to go around to compensate somebody for what happened. So I think that's also like getting back to Austin's point about insurance and people not really knowing what goes on behind the scenes in terms of insurance companies being the ones who are actually, they're controlling the purse strings behind the scenes. The average person doesn't know that. So like if I get in a car collision, somebody rear ends me, I sue them and I go to trial, it's, Christopher Adamson versus John Doe. So then if John Doe, comes in and let's say it's like an 85-year-old man and he's at the defense table and you have all these jurors that are like, oh, I mean, Chris is badly injured, but if we give him like $1 million verdict, it's going to bankrupt this poor guy. So our hands, like we're two arms behind our back, not just one, but two, because we can't tell the jury, we can't tell them don't worry about where the money's going to come from, but we can't say there's insurance behind the scenes who's going to pay this, because there's a specific jury instruction that the judge will read to the jurors about insurance and like not to consider insurance. And you only can consider the evidence that comes from the witness stand. And then you go back in the deliberation room and you guys figure out your verdict. But with them, like some jurors are savvy enough to know at this point that there is insurance behind the scenes, but they're still not supposed to consider that because that's not evidence. So a lot of times for us as the plaintiffs, we're behind the 8 ball because we're coming into trial and there's things that are important to the average juror's deliberation about the case that we can't tell them.
But so in I guess like how the insurance company or the government should function, right, is that they would in good faith pay out the claim as it should be. I
mean, good faith is a good term because insurance companies do have a fiduciary duty to like fairly and properly, quote unquote, adjust these claims, like evaluate these claims. Like they have a good faith duty. They have a fiduciary duty to their insured, and their fiduciary duty, I believe, is supposed to also take into consideration the claimant, not just the insured's like obligations or responsibilities or whatever, but they have to consider the claimant as well, like the injured party. So you can't just be completely biased against your insured, but a lot of insurance companies take that tack, like they believe they're insured, or they take the position that we're here to protect our insured at the cost of the claimant a lot of times. So then there's like this whole other area of law called bad faith and personal injury cases, which are third-party cases, meaning like if I'm driving and I get rear-ended by somebody, if I make a claim against their insurance company, that's a third-party claim. But there's a whole bad faith aspect that has to do with first-party claims, like you're seeing with like the Eaton fire and stuff like that, where people have their own insurance, like homeowners insurance, and they have a claim, and their homeowners insurance is denying their claim for spurious reasons. Like that happened a lot when Hurricane Katrina happened, and people were making claims because they lost their homes. And then like the insurance companies were improperly denying claims based on whatever it is, like flood exclusion or force majeure exclusion or something like that, but they were doing so unfairly. So I think in terms of like the narrative about insurance companies, there's been a lot of propaganda, as Austin said earlier, put out there against like personal injury attorneys, et cetera. But there's not a lot of quote unquote propaganda, or if you just want to call it information, that's put out there about insurance companies, because we're not a huge lobbyist or lobby. You know, we're not a huge industry in the sense that like we can go to Capitol Hill and have like a national plaintiffs attorneys union that has like the same type of leverage that some of these other like insurance industries or some of these corporations like, you know, Koch brothers or Uber now, which we're seeing like they have access to huge amounts of capital to put this propaganda out there about what we're allegedly doing. But people don't know the real truth about what insurance companies are doing behind the scenes, like denying third-party claims, denying first-party claims, et cetera. And that goes back to what Austin was saying. Like we see the sausage being made because now that we do what we do, we get a peek behind the curtain and we see what's really going on. So I think part of what, you know, we hope to do, not just with this episode, but with this podcast, is just educate people, educate consumers, be actually fair and balanced, and just providing the information and just put it out there for people to assess and make their own determinations.
So I guess that's a good kind of transition to talk about, we haven't really talked about like fees at all. And, you know, just in the past couple of years, in the California ballots, at least, and this has been happening in other states as well, like Texas and Nevada right now. There's a lot of ballots out there about attorneys' fees, which I think as representing the average person here, doesn't really mean much in my everyday. And yet, you know, what we're here to talk about is that it actually really means a whole lot to my everyday. And that's a weird thing to think about. Why would a lawyer's fees have anything to do with my daily life? So I'll kick that to you guys.
Yeah. Okay. So, so the contingency fee agreements, the fact that we have this as part of our legal system, is truly incredible, and one of the very few areas in our economy where it doesn't matter who you are. You could be homeless, destitute, on the side of the street, barely able to string words together, and you can have access to the highest quality legal representation that money could possibly buy because of contingency fees. That's why. So this is a strategy that's now kind of being adopted by insurance companies through their lobbying organizations to try to figure out how they can reduce that fact and hurt that ability for individuals to get high quality representation. And the way they're doing this is by trying to say, look, these lawyers are getting rich off your pain. That's not fair. This is your settlement, your award. You know, we need to cap this excessive greed where they're asking for, 40%, 50% in contingency. 50 might be high, but 40%, 30, it's so high. And that's not fair. It's not right. You got hurt. You're entitled to that compensation. And we have to stop them from doing this.
Can you break down what a contingency fee actually means?
Yeah. No, yes. Okay. So let me do it this way. So I want to comment though on that point that if you don't understand what's going on behind the scenes, that not only is reasonable to feel and to think, but it's legitimate. Like if you don't know anything else, that's a fair concern, because the award that you get at trial or the settlement, that is for full compensation to make you whole. That's what that's for. And so, yes, we should ask how are the attorneys getting paid. Now, for the contingency fee, there's only a couple ways in which lawyers get paid. And it's helpful that we talked about the public side a little bit because you have public lawyers. When I was a prosecutor, I was a government employee. I got paid from taxpayer dollars, a salary. Public defenders, same thing. Then in the private sector, you have sometimes general counsel who might be hired by way of like a general retainer every year, or they're just paid a salary. That's kind of a smaller category. The overwhelming majority, I mean, maybe 80% plus of lawyers are getting paid hourly. Okay. So they have an hourly rate. And then when they get hired, they charge their hourly rate for their fees. That's their services. And that's in addition to the costs of litigation. Costs of litigation are, the filing fee, paying the process server to take your subpoena to the right person, or if you need a deposition, getting a court reporter involved. All of those costs of litigation are also part of what then you have to charge. And
that gets charged to the person.
To the client. Correct. Yeah. Because it's their case, exactly. And so if let's take contingency fees out of the equation for a second, you get hurt, catastrophically hurt, and somebody else undisputably is at fault. So they ran a red light while drunk, and you need payment for your medical bills, compensation. So you go to a lawyer who's going to charge you hourly. Now, hourly rates have skyrocketed. If you want to, let's say you want to get the best legal representation possible. So you're going to a blue chip law firm, Gibson, Dunn, White and Case, Latham Watkins, whatever. And these partners are, charging $2,000, $3,000 an hour. Okay.
I got in the wrong business.
The associates, are able to charge less than that, but let's just say $1,000 an hour to kind of keep it easy and consistent. And how many hours are they going to need to work on your case? I just recently had to do an accounting for a minors comp, which we'll talk about in a second. And on that particular case, we settled before experts completed, and that was about 100 hours that I calculated of work. Okay, so that's $100,000 in attorney's fees, and the cost of litigation up to that point was $160,000. So our firm paid $160,000 for the costs. If you had to get that from an hourly rate lawyer, the overwhelming majority of lawyers out there, that's what you're paying. You're paying that out of pocket. Do you have it in your account? Invoices are coming every month, by the way. So they filed the complaint. It took them, maybe they'll charge you for half hour on the complaint. So they filed the complaint. Okay. Then we needed to serve the defendant. So some costs there. And then the end of the month, they gave you an invoice. So here's the invoice. And you're paying it as you can. Okay, I'm going to reach in deep. Here's $1,000. Here's $1,200. And then the next month comes, I can't pay. Oh, okay, that's fine. We're done. Right? And then now you're screwed. Now you have a complaint filed and you've got nothing to do. So that's what it looks like for people. Corporate insurance companies, they can afford that.
Right. So
those lawyers that are working for insurance, usually they'll say, hey, we'll give you 100 cases this year to work on. So it's guaranteed case.
So they're not
flow.
In-house at insurance.
So some
of them are.
Some are.
Oh, okay.
So it varies. So insurance companies, if there's a claim with their insured, they might start it in-house and assess it, and then they might start to handle it or then hire out another firm. And if they hire at the other firm, it's this hourly rate. And sometimes those will be negotiated in various ways. So even if my hourly rate's $1,000 an hour, if I'm on the defense and I want your 100 cases for job security, right? Then maybe I'll say, okay, for your cases, I'll work $500 an hour for the bulk, right? But guess what? You can't do 100 cases. Let me, that agreement's not available to you to offer the lawyer. So they're not going to give you a discount. They're going to charge you the full hourly rate. So insurance companies can afford the hourly rates for high quality lawyers. Multinational corporations can afford those hourly rates. And so it's in their interest to try to convert everything in society to an hourly rate based system if you want access to lawyers, because they're the only ones that can afford that. But what we've done is we've said, let's actually make law accessible to everybody, because in our system, this is the one place in front of the judge in the courtroom where David can meet Goliath on an equal playing field. So how do we do that? Well, we should give them the opportunity to find lawyers who are willing to work on a contingency. The contingency means I get paid contingent on winning. So I would overhear Brian Panish say quite often when I was at his firm, defense lawyers get paid hourly. We get paid sometimes. That's how it works. It's a higher risk industry, and so you have to evaluate the case. There's certain constraints on whether you take on the case. Basically, 3 legs. The first is liability. Can you prove it? Second is damages. Are they significant? Third is, can you actually get paid? Right? Like Chris was saying, you can have great liability, great damages. If you can't get paid on it, it's not a great case. So you have those 3 limiting factors on case quality. And you say, look, I will litigate your case. You won't have to pay a dime and you won't have to take on the risk. So in some contexts, you might even think like, okay, we'll front all the costs, but then if we lose, you still owe me the $160,000, right? We don't do that. We say, if we work on your case and we spend $160,000 in litigating it, we swallow that. Mm-hmm. That's on us. That's our risk. Significant risk. Not to mention the opportunity cost. So right. we spent 100 hours working on your case. We didn't spend that on this other case over here. So because of all of that risk, with the agreement is whatever you recover, we get 40% on the attorney's fees if it's filed. If we don't have to put in all that time and energy and effort and we can settle it before filing, maybe we'll reduce it. Like that's a 30% rate. But the more investment we're making, the more risk we're taking on, the more that rate needs to increase to make it worthwhile. Mm. So that's how the system currently works. And there's a number of different consequences to getting rid of that or to capping that 40% at 30 or 20.
When did that system begin?
I don't know.
The contingency fee system.
Has that always existed for
it's pretty
PR?
It's pretty fairly old. Yeah.
Yeah.
I've also seen some some entertainment lawyers do it contingent on deals.
Yeah.
Because I guess it's that same sort of like opportunity place. But like, are those really the only places that like, or I guess law sects that do that?
Well, in certain other areas of law, it's actually proscribed. You can't have a contingency agreement because you don't want the attorney having an interest in the resolution of the case, like family law, for example. So like family law, divorce lawyers, they're not allowed to work on contingency because like, let's say if they have a vested interest in the outcome of your case in terms of a contingency agreement, it could affect how they quote unquote prosecute your case or deal with the other side or something like that. So like a lot of in certain other areas of law, state bar, et cetera, they don't want the attorneys to have an interest of the case because because it can affect your ethical obligations.
Interesting. So it sounds like there's like how attorneys get paid is really critical to the profession, consistently talked and thought about.
I mean, I think it's, as Austin said, it's critical for our profession because it allows anybody to have access to the civil justice system. Like we've had clients who have, been unhoused and living on the street, et cetera. And we find a way to make it work because just because you might be in an adverse situation doesn't mean you're less entitled to justice or the full measure of justice than anybody else. And so if we start stripping away those rights or making it harder for people to have access to the civil justice system, I think you're doing a disservice to one of the foundational pillars of our country, which is you have access to a jury of your peers. You have access to the civil justice system.
Justice response, I guess, obviously in the criminal justice system, you have public defenders. Mm-hmm. You would be assigned one. Mm-hmm. If you can't afford one and one's assigned to you, like, what does that look like? Is that like
in the criminal justice system?
Is that the same? Is that a contingency fee or is that just you don't have to pay anything?
No, those are government.
Those are government lawyers. So you are technically through tax dollars paying.
Yeah. Through taxes, yeah. So yeah, exactly. But that has you have to qualify for the public defender.
Interesting.
So if you make too much, you won't qualify to have a public defender. So that way the resources are limited to only those who need it.
Wow.
In that way.
Generally indigent people.
Yeah.
But there's arguments even within the criminal justice system that if you have more money, you're going to have better access to justice. Like,
right.
And how he just said, like, if you don't make enough, and then you qualify for a public defender. Like, there's tons of stories out there about, public defenders being overworked. They have stacks of files on their desk. They can't give their files like the proper attention they deserve. And there's a lot of innocent people in those files, but they're going to get buried in the system just because their public defender didn't have enough time and energy and resources to devote to their file versus, other people out there who might have millions of dollars in the bank. They can go and find the best criminal defense attorneys, because criminal defense attorneys, in terms of how they get paid, typically they want a retainer up front, and then they'll start working against the retainer. And then as the retainer runs out, they're going to ask you for more money to keep working. So they're not paid on contingency, but you have to have enough money to pay them out of pocket to be able to pay for their representation. Not everybody has that. Not everybody has a spare whatever amount of money in the bank to hire a Johnny Cochran or an F. Lee Bailey or Barry Sheck. There's a reason those guys were called the Dream Team, because those guys were at the top of their profession when that happened in 95. Like F. Lee Bailey, if you look that guy up, long and storied career as an attorney. Johnny Cochran, everybody knows his credentials. And then even some of those other guys that people don't know as much because their names might not have been as big at the time, like a Barry Sheck, who was like a DNA specialist, who was one of the linchpins in that defense. So, he had the money to afford those guys, and we see what happened, but not everybody does.
Gotcha. Okay. So in the civil justice system, contingency is the way that people typically are able to.
Yeah.
Okay. That makes sense.
And so what's been happening with these pushes to try and cap the fees from 40% down to 20%, 25%? Well, what would the consequence of that be? Again, this is a private business. The way that we've set up this legal system, if you want civil justice, you need to hire a private business, private firm to do that. And if that gets reduced down to 20%, what that effectively means is now you're asking these plaintiffs' lawyers, okay, is it worth the risk? Is it worth potentially losing from case to case hundreds of thousands of dollars and then over in aggregate millions of dollars when what you might be making is going to be half now of what you were otherwise making? So if you have, and I would think of it kind of this way too, there's a couple different. So if I wanted to go to the defense side, I'm highly confident I would do very well. And I could make very good hourly rates if that's what I wanted to do. It'd be hard to sleep at night, knowing what I'm doing. But, you want lawyers who could be doing other things, who could be making money in those. You don't want lawyers who are forced into a certain type of practice because they can't do something else, right? You want the people who could do either one and they're choosing to do this one. That's what you want. But if you suddenly make this area of law not particularly lucrative because of these caps, those high quality lawyers are just going to do something else in terms of the financial incentive. It's not 100%, but you're going to have some percentage that say, look, I'm going to provide for my family. I got my mortgage to pay and so on. I'm going to go into this other area of law now because I can, and now I'm going to be representing clients who can pay me. So the first thing that it's going to do is it's going to reduce by some percentage the highest quality lawyers in this field. That's going to reduce access to high quality representation for ordinary individuals. The second thing it's going to do is it's going to require more volume. So firms that are taking on cases, they're going to have to compensate for that loss in terms of have more cases. And what does that mean? That means less attention, less devotion to each individual case. It's going to be harder to really pay attention to each individual case in the same way. The third thing it's going to do is it's going to reduce the tolerance for risk. So instead of paying $160,000 in costs, now maybe I'm going to try to just litigate this $50K. Now that $50K investment means I'm not hiring all the experts that I think would be maximally optimal for this case. I'm going to hire the two that I have to avoid malpractice. I'm going to, instead of doing these 3 investigations and having inspections take place and bringing these 4 motions, I'm going to do 1 inspection, maybe bring 1 motion if I absolutely have to, right? Now those moves, each of those, pulling away from full zealous representation helps who, right? So you're getting lower quality representation in terms of the competence of the attorneys in the industry writ large. You're getting lower quality in terms of the resources that are available to those firms. And it's going to reduce the tolerance of risk for more complex cases where liability isn't obvious and clear because you're going to have to work to prove it. So it actually creates a bar on access. That's what it's designed to do. It's going to change the industry so that people who have cases, who have been hurt, who need compensation, who are entitled under the law for that it's going to be harder for them to get high quality representation. But that's the goal.
I'll also say we've kind of already seen this play out in real time back in like the 70s and 80s to kind of close the loop on medical malpractice and tort reform, because that was successful. And what that did, it wasn't a cap on attorney's fees. It was a cap on damages. So what happened in medical malpractice cases is they capped your pain and suffering in medical malpractice cases at $250,000, that's gone up recently, right?
Yeah.
But so in medical malpractice cases, no matter how grievous the injury, so let's say it's a malpractice case and the doctor did something to a patient that fell below the standard of care, and now that person is paralyzed, versus if the doctor did something like, let's say the doctor was supposed to amputate the right pinky and they amputated the left pinky instead. Those two cases, in terms of the pain and suffering damages the patient has or the client has, are capped. What's not capped is future medical care, past and future medical care. So we saw that play out because those doctors were successful through their lobbying and implementing damages caps. And then what happened is, over time, there was an outflux of people, outflux of medical malpractice attorneys from that industry, because they just said, I can't even really afford to be in this industry anymore. I can't make a living in this industry, it's not worth it. And what else you saw was the attorneys who remained in the industry, they also became more discriminating in the cases they would take. So it could be a righteous case in terms of liability, but because the pain and suffering damages are capped, and because maybe the future medical bills aren't really high enough to make it quote unquote a worthwhile case, now those same attorneys are turning down cases that they would have otherwise taken, which goes back to the chilling effect on people having access to attorneys, because now attorneys it's a righteous case, but I'm sorry, because I can't take it because of the damages caps. So we have seen that play out in real time already. And now they're just trying to do the same thing with caps on attorney's fees and potentially caps on damages. Because right now, the types of cases that we handle for the most part don't have caps on damages. But if these lobbying entities and corporations out there like an Uber or somebody else, if they could get caps on damages and attorney's fees, it would essentially just wipe out the entire industry, which they would be fine with, because now it's we can be bad actors without consequence.
Can you speak to, I think hearing that, I'm either, your percentage goes down or the damages are lower. So you make, maybe $200,000, not $400,000, whatever. So I think average people hearing that, I still don't think that fully hits, because I don't understand the operating costs of a trial. What goes into when you're taking on a case? There's so many different factors that I think we don't, expert witnesses or investigate, all of that. What are those operating costs that kind of build the whole financial structure of what you're thinking of a value of a case? Does that make sense?
I think before we even get to that, those same people that you're talking about, they're oh, I can't believe this personal injury attorney is making, let's say, $1 million a year. They have no problem with the CEO of X corporation making $40 million a year. Yeah. Or that same CEO who fucked up that corporation and then got voted out by the board might have a golden parachute when he leaves, or she leaves, of $20 or $30 million a year. So for whatever reason, and this goes back to tort reform propaganda, et cetera, this idea that personal injury attorneys are the enemy because they're making so much money. People don't have those same issues or concerns when you think about pretty much any other industry in America. And if America fancies itself as a free market capitalist society where you can pull yourself up by your bootstraps, you can make whatever amount of money you want to make because that's what America is. Yet for this small, specific sect of people in this industry, we have a problem with that when CEOs, head coaches of sports teams, or even college teams at this point, there's people in every other industry who are making grossly more than even the most successful personal injury attorney is probably making, but people don't have an an issue with that. So I think like that's an important narrative. If we're going to think about what the quote unquote real issue is, like I would challenge those same people who think they have a problem with a personal injury attorney making X amount of money. It's like, well, why don't you have a problem with other people in other industries making probably 5, 10, 20 times more than what we're making? Like people don't have a problem with Jeff Bezos, right? They're like, wow, that guy's a brilliant businessman. Like he built this from the ground up and he made all this money. There's a lot of plaintiff personal injury like founders and owners out there who did the same thing. They started their business from scratch. That's what me and Alan did. It's not like we came from money, had a bunch of money in the bank. We built it brick by brick from the ground up, the same as any other business owner. And there's a lot of other personal injury attorneys and business owners and operators out there who did the same thing. So I would just challenge people to kind of that idea they have that this industry is making too much money, like extrapolate that to other industries.
Right. You don't have that same bias against tech.
Yeah.
And to answer like head on, the operating costs are significant.
Yeah.
And this is actually one of the things that will also have a chilling effect on taking on cases that cost a lot of money. There's a lot of firms out there. Like if you go to a solo practitioner who's trying to do his own thing and you ask him or her to represent you, they're going to have to look at their war chest, right? They're going to have to look at their capital. How much do I have to actually put towards this case? Smaller firms have less capital to do that with. And so firms that are able to reinvest what they make in profit from a case allow them to actually represent future clients effectively because they put that aside so I can actually work up the cases. This is one of the things when I was coming out of the DA's office and when I was looking for a firm to work with and join, I was really impressed with their firm. Was that a lot of firms that at the time were their size didn't even have the war chest to be able to actually hire all the experts you need to get the illustrations that you might need, that sort of thing. And as a result, you get tremendously diminished representation in terms of quality, tremendously. And that makes a huge difference. The quality of the lawyer and the resources of the firm make a giant difference in the actual ability for individuals to get justice. And as a result, that's what you're paying for on that 40%. A good example of this, I think, is just recently I had the minors compromise I was mentioning. Let me explain minors compromise real quick.
What minors compromise?
A minors compromise. So in our system, if a case is settled involving a plaintiff who is either mentally incapacitated in some way, they're senile, they needed a conservator, or a minor.
Oh, okay.
Then before you can actually settle the case and get paid and resolve it, it needs to be approved independently by the judge. So the judge is basically making sure that minor or that mentally incapacitated person isn't getting taken advantage of. Right. That's the purpose. And so in those minor compromise cases, the judge gets to review what happened, what are the terms of the settlement, what's the work that went into this, et cetera. And quite often that judge will look at it and say, okay, maybe this is 30%, maybe this is 25%. It's adjusted depending on that case. And so I just, submitted one of those petitions and had that hearing on this case. It was a minor who was bitten by a dog. And we got a very good settlement. I articulated, what we did for the judge, asked for the 40% that, we thought we were entitled to. And we got notes from one of the examiners of the court that, hey, the typical for these cases is 25%. So, okay, if that's what you think. But after the judge read through everything we did and saw the result that we got, he said, no, I'm approving it. That was absolutely reasonable for the work that you did on this case. Mm-hmm. We looked at verdicts and settlements for comparable cases in that venue. And if you look at what this boy ended up with netting, even though we took 40%, just the net result that he got would have set a record as a separate settlement in toll or award for that venue, for that type of case. So he ended up with dramatically more than I think if he went to another firm who did a half-assed job of representation, who was trying to save on costs. What I spent in costs on that case actually would have been like the third or fourth highest settlement for that type of case in that particular venue. And so most firms, a lot of firms, really hesitate to invest it takes a firm with the resources, the willingness, and the confidence in our own ability to get full representation for a client. And so that's why the judge said, yeah, your 40% is reasonable because of what you did. So that's to say, like, the quality of representation matters, the resources matter, and that's why they're attacking it and saying, let's cut that so we can get rid of those advantages.
Right. So then can you go into, like, when you say, like, what I spent on the case, like, what does that mean when you guys are doing a case and you're spending a lot? Like, what are you spending it on?
Sure.
What does that mean?
The biggest costs are usually experts and then trial.
Okay.
So you can usually save costs prior to expert discovery somewhat. But even then, you're still probably going to get around 100K. Logistically, what this looks like is there's Westlaw, which is a resource database that we do our legal research through. And so that costs money when you're using that. When you're filing the complaint, it's a couple $100 with the court. When you're hiring a process server, so you have to serve somebody with a subpoena. Okay, what does that mean? That means you fill out the subpoena, you sign it, you give it to a process server, and now they're going to go serve them in person. So we got to figure out where they are. We got to stake them out sometimes. So there's sometimes hourly rates. We got to pay them to go do that. You hire investigators to go out and investigate who this defendant is and what their background is like. Maybe if it's a premises liability, doing a canvassing of the area to try to see cameras. Did anybody collect it? The basic workup of investigation it accumulates over time as you're doing all of that. When you retain an expert, usually there's an initial retainer, we'll say $5,000 for a relative, a smaller one. And then they have their own hourly rate. And you need them to go out and do an inspection. So now they're flying out to go do the inspection. They have to do the inspection itself. They charge whatever they do for that. So there's all of those pieces of workup along the way. Any motion you need to bring, there's a filing fee, et cetera. So that's that part of it. And then when you're deposing experts, the other side's expert has an hourly rate that you have to pay to take their deposition. So they'll say, oh yeah, I charge, $2,500 an hour. So you can depose me however long you want, but that's what you're paying me. So then we got to take that. Now that is another huge limiting factor. I will often take, 6-hour depositions of their experts, 7 hours. A lot of lawyers will take a 1-hour deposition of the other side's expert because they don't want to incur the cost. And so they try to be really efficient. They try to do what they can. And frankly, if I can, then that's what I'll do.
But the insurance company can afford to depose your...
Right. We see that on the flip side, a lot of times when the defense attorneys are deposing our experts, they'll be like, oh, I have a check for 1 hour, because the insurance company will only give that defense attorney a check for 1 hour of our expert's time. So they have to get it done within 1 hour. So even though insurance companies have lots of money, they like to save their money and not spend their money. But also, like, in terms of, so everything that we're talking about, like the costs, these are just expenses that we're fronting. We're paying them out of pocket. So over the life of the case, like, if you think about the complaint gets filed here and then trial is here, all these things are happening during this timeline. Like you said, the filing fee to file the complaint, serve the complaint. When we take a deposition, we have to pay the court reporting company. A lot of times depositions are via Zoom now, but they're still set up through a court reporter company. So we have to pay to take those depositions. As the case gets closer to trial, either side, plaintiff or defense, you need experts to help you prove your case. So we have to pay money to retain experts. That's not cheap.
Can you give an example of, like, what experts you would bring on for something? Like, I know you had a battery expert at one point.
Yeah. So, I mean, it's kind of a unique case. So I'll give you kind of a standard run-of-the-mill. So,
orthopedic doctor.
Yeah, so
pretty much all our cases.
So let's say it's like an auto case.
Yeah.
Basic auto case, rear end, somebody's spine gets injured.
Yeah.
And maybe they also like had a coup contra coup brain injury. Okay. So these are some of the initial indications. Now, when I say they have a brain injury, how do I know they have a brain injury? I don't know, right? You need experts. And so how do you prove that? Okay, well, if I need to prove a brain injury, I guess that means that I need to hire a neuropsychologist to perform a 3, 4, 5 hour battery of tests to evaluate cognitive performance and to evaluate memory function, all this kind of stuff. All right, so we'll hire the neuropsychologist. But then the neuropsychologist is there to evaluate psychological function in light of the injury, but not necessarily to diagnose the brain injury itself. And somebody who can actually explain neurologically what's happening. So that's a neurologist. Okay, so I need to hire a neurologist and a neuropsychologist. Okay. And then when we're looking at the orthopedic issues, so this person has a couple things going on. You have nerve impingement. It's causing chronic ongoing pain that requires a lot of pain management. So what we need is a neurosurgeon or an orthopedic surgeon to evaluate the spinal injury, but also maybe a pain management specialist to specifically address the pain, because the orthopedic specialist will understand some aspects of pain, but the pain management specialist will be able to really opine on those modalities and treatments and that sort of thing. So now we have a pain management, orthopedic, neuropsych, and neurologist. Okay. Now what we need to do is liability is disputed. Oh, they're disputing liability? Okay. So then I guess what we need to do is hire an accident reconstructionist. This is like somebody who uses physics and engineering to evaluate the dynamics of force involved, what happened with the vehicles. But you know what they're going to say is they're going to say, yeah, this was a big force, but that force wasn't enough to cause the injury. So now you need a biomechanical expert who can actually explain how those forces impact the body, how that would actually cause the coup contra coup within it was enough force and at the right angle to cause the kind of injury that we see on the radiology. Oh, we have radiology. So what we're going to need to do is hire a radiologist who specializes in interpreting those films and can debate their radiologist when they come out. Okay, so now we've got most of liability. Oh, but they're also arguing that part of the absence of liability was that they couldn't see in time. There was a perception reaction problem. Well, what kind of expert would be able to opine on whether there was a perception reaction? A human factors expert. Okay. So now we have a human factors expert, an accident reconstructionist, a biomechanical expert, a neuropsychologist, a neurologist, and a radiologist. Okay. Are we good? Are we good? No, because you know what? We have to prove the future damages. How are we going to put numbers in front of the jury as to how much it's going to cost for all the future medical care that this person is going to need? How can we actually tell them what the reasonable value of those future medical costs are going to be? We need a life care planner. So the life care planner comes in and they talk to the doctors. The doctors tell them what the future medical needs are. And the life care planner says, how much is that going to cost based on my expertise? So they put together a life care plan, which is all the medical care is going to be needed for the future. Wonderful. But the law actually requires that to be discounted to the present value, because you can accrue interest over time. So you have to account for the future interest rate. How do you do that? We need an economist. Okay, so now we're going to hire an economist or a CPA to come in and address that issue. And now we're also claiming this individual, because of their injuries, they are going to lose wages and they're going to lose earning capacity. And so who can provide those opinions? Because if I can argue this, I can talk about, hey, this is going to change. This is what the job market looks like. But what I say is not evidence. So we need a vocational rehabilitation expert who can come in, who can evaluate the plaintiff and assess, what they were able to do, what their skills are, and if they can't do this job anymore, what other jobs they might be able to do, and what their lost earnings are actually going to be over time, and what their lost earning capacity is. And now we've got the economist who can actually put numbers to that as well. Okay, so what do we have? We have a neurologist, a neuropsychologist, an accident reconstructionist, a biomechanical expert, a radiologist, a human factors expert, and a life care planner and an economist. Maybe we're good.
A neurosurgeon and a pain management.
Oh yeah, and that's right. A neurosurgeon or an orthopedic surgeon and a pain management specialist. Okay. So now that is how I litigate those cases. Now, theoretically, if you wanted to save costs, if I was confronted with this, I don't want to over leverage myself and I want to keep it narrow. Theoretically, I might be able to say, okay, well, what is the evidence in this case on liability? And I'll just hope that the jury doesn't buy their nonsense, right? So on the perception reaction time, I won't hire the human factors expert. I'll just hope that they, understand that this is enough time. And I'll have the accident reconstructionist, the biomech. Maybe I don't use the biomech. I just do the accident recon. They articulate the forces involved. They say it's a 10-mile-an-hour delta V. Let's just hope that the jury understands that a 10-mile-an-hour delta V would be enough. You're rolling the dice when you do that, right? Because you don't know how that jury's. A lot of jurors need to hear it from the expert to understand the perspective on what this actually is. You'll get some defense experts who will come in and they'll talk about how, a certain delta V amount of force, like a 10-mile-an-hour delta V is like sitting down in a seat. Like that's how much force it is. Like activities of daily living, which completely distorts the reality. The 10-mile-an-hour delta V, the quickness, the acceleration in the context of sitting in a vehicle and getting hit versus sitting down, it's playing games. And if you don't have a response to that from an expert who can call out the bullshit, then it's just their bullshit. That's the only evidence in the whole case. And so you need these experts to also address what they're doing, so that the jury.
And they always have experts.
Doesn't get lied to.
Well, so let's say like if they designate an expert on a topic and you don't designate an expert on that topic, that's also a risk. It's actually a malpractice risk, I would argue, because now they're experts. So let's say you don't do the human factors expert. We don't retain a human factors expert, but the defense does. And then we go to trial, and that defense human factors expert, that testimony is going to be unrebutted. So now the jurors are like, well, that must be true because the plaintiff had an opportunity to have their own human factors expert and they didn't have one. So you also, like, if you're trying to save costs, et cetera, and they designate certain experts and you don't, that's a risk as well. It's a malpractice risk. If you go to trial, you're most likely going to lose or, not do as well as you wanted to because you didn't designate the proper type of experts and you had an opportunity to.
Which would eventually make someone not want to take a case.
Well,
because
plus,
they
like,
open themselves up to that.
The other thing is the experts that we hire, they're top tier people. Like all those experts that Austin named that he's going to hire in that imaginary case, they're going to be at the top of their field. So they're going to be expensive. Right. They're going to take their time, do their due diligence. They're going to have well-crafted opinions, but that costs money. And that's all money that, again, we're fronting out of pocket to retain these people to put the case in the best possible position to either settle or we take it to trial and swing for the fences and get a huge verdict.
And that's a really good point. Part of that quality degradation that will occur if you have a capping of fees, and so we're trying to cut costs, having the best experts versus like B+ experts is a huge difference. I cannot overstate. And it's not the cynical reason that you might think, which is like, oh, you want the experts that are going to play ball. No, it's kind of the opposite. It's experts that can stick to the truth and defend it in the face of all the tactics and games that the other lawyers engaged in when they're cross-examining. If you get somebody who's academically very sharp, they know what they're doing, but they can't communicate to a jury and they don't foresee what this defense lawyer is doing to like trick them and to play games with their words, it's almost worse for your case because now they're just a sitting duck and now your expert is getting played with like a little toy, which if you're a talented lawyer, you know how to ask questions and you're dealing with somebody who doesn't know what you're doing, you can tie people up. And so you want an expert who can articulate themselves, connect with a jury, and has the competence, background, and expertise to be able to do that effectively. What I see sometimes the defense will do too is they'll get really good talkers who can smooth talk that jury. They'll look at them, they'll explain things very common sense way, but the integrity of their ideas are just not there. They're
and do
lying.
People sense that?
What's that?
Do people sense that?
It depends.
It depends, but so I've seen them get away with it. You need another expert to call them out on their bullshit. You do. If you don't have a countervailing, if it's just them by themselves and the jury has nothing else to go off of, then that's the truth.
Right, but if it's peer-to-peer evaluation.
Peer-to-peer, then I think they can, as long as you have somebody who can articulate themselves well, who understands the tricks that are being played, then the truth will out. But if you have somebody, if you're just saying, hey, I want somebody who is a really good doctor, that's great to an extent. But if they're getting their words twisted and the jury can't really follow them very well, it's ineffective.
Yeah.
And the whole point of a trial is to communicate effectively to a jury. That's it. So that's another part of the quality degradation that you're going to experience in the litigation of your case. It's not just that you're going to have less experts, you're going to have worse experts.
Yeah, because to piggyback on that, like the communication is very important because like as he's naming all these experts and talking about what they're going to cover, I'm looking at your face like you have no idea what these people do. You don't know what Delta V is.
No.
So you need an expert who can come in and explain that to you. Like the best experts, it's like they're explaining something to like a high school physics class, or the common phrase is like, explain it to me like I'm a 7-year-old. Right. So like they can take something that's very high level because we're dealing with very technical testimony, like a radiologist report, a neuroradiologist who's testifying about a radiological imaging, or an orthopedic doctor who's talking about the body and, vertebrae and discs and stuff like that, or radiculopathy, like stuff like that. They have to be able to communicate that stuff to you as if you were a 7-year-old, so you can retain it and understand it, and then also be on guard against the defense attacks and defend against those attacks. So it's not just necessary to have like a high level of intelligence, because there's a lot of experts who are super smart, but they can't communicate, and they can't communicate in a simple way to make it understandable to the jury. Like, we've all been in trial where like our own experts are running off at the mouth, and you sneak a peek at the jurors and they're like completely tuned out because this person can't communicate well. So that's very important. But that goes into like the quality of the experts that we're retaining, because we take that into consideration too. It's not just the qualifications, but like, how many times have you testified? How many times have you been deposed? Like, are you comfortable testifying? And then we run through mock testimony with them, like either in an expert deposition or at trial, to get an understanding of how well they're going to do at trial. Because that's very important. Because when you're getting to like, the level of cases that we're handling, like not every case is important, right? But like some of these cases, there's huge exposure. There's like catastrophic injuries, wrongful death, like high exposure cases. And so we'd be doing a disservice to the client if we weren't getting the best experts and taking all these things into consideration, because this is their one shot. Their one opportunity to get justice for what happened. It's not like if we go to trial and we don't do as well as we could have, we could be like, oops, let's have another trial. Like, this is their one opportunity. So that's something that's always in the back of our minds, because we know if we're not putting these cases in the best possible position, we're doing a disservice to the client. And oftentimes these clients have come to us, they don't know us from Adam. Like, they might have just done like a Google search or something like that. They found our firm. They don't know anything about us, the quality of our services, whether they can quote unquote trust us. So again, we'd be doing a disservice to them if we were offering them subpar services or not the highest tier services that we could possibly offer.
Right.
That reminds me, actually, there's another element to this that it struck me as another reason you don't want to cap these fees. And that is the fact that people don't know how to find good personal injury lawyers.
So that was my follow-up question, because you mentioned two things about when you're looking for a firm, just offhand, it was like high quality attorneys, but also resources to them. But if people don't know anything about any of this, and they don't even know the questions to ask, what are they left with trying to choose? So
what I was going to answer that with is to first kind of give a general overview of what the PI market, what business models there are. And it's changed a bit over the past 10 years, but like one model that exists is pure high volume. And a lot of the billboards you see, like we are basically here to collect hundreds of thousands of PI cases. And we're going to try to organize these and try to settle off as much as we can, as fast as we can. And then what they do is, if they get a case that happens to be a very good case, that triad of good liability, good damages, and there's somebody who can pay it, they ordinarily are not going to be able to try it. They're not going to be able to litigate it. They don't know how to litigate it. They don't know how to litigate it well.
Because it's not their business model.
It's not their business model.
Yeah.
And so if they have lawyers, maybe just to oversee how the pre-lit stuff is being handled, but they don't know how to handle actual litigation files. So what do? Well, there's some other firms that just litigate cases. They just try cases. They don't really market themselves. You can't really find them on Google very much. And that's all they do is that 99% of their cases come by way of referral. And so what does that mean? Well, those smaller firms or those high volume firms who don't know how to litigate very well, if they get a valuable case, what they can do is they can go to another firm. They could come to our firm and they could say, hey, I've got this really valuable case. I don't know how to litigate it. Can I refer it to you? You handle everything and then just pay me a referral fee. And those referral fees are sometimes half. So that whatever the attorney's fees are, cut those in half. Sometimes it's just 30%. Sometimes they're always negotiated. They're always different. But often they can be up to half, which would mean 20%. And so that there's a value in the firm that's litigating it by getting this case that they wouldn't have otherwise had. And then there's a value from their perspective of not having to work it up and still getting, a percentage on it.
Right.
The client benefits because the case is making its way to the firm that can handle it the most. And it's in the interest of that attorney, the referring lawyer, to make sure it gets handled the right way. This is a $10 million case, right? A $20 million case that is going to get handled. And I'm going to make more, the client's going to make more, and the other firm's going to make more. If you cap it at 20, how much left is there to refer it?
Right.
There's like nothing left. So now the client who hired this guy who doesn't really know what he's doing is stuck with him and doesn't really know where else to go. So part of allowing for a larger contingency fee also creates this dynamic where if you have a case that needs to be handled the right way, it makes its way to people that can handle it because there's that referral fee agreement. And then there's some firms where they do both. And that's kind of basically what ours is. We do both. We try to market. So we let people know, hey, we can handle your case. And then it was valuable. We can keep it in-house because we have litigation attorneys as well. So some have been trying to do both as well, but there's those two models. And so it breaks my heart. It really does. And I've seen this so many times where people have a legitimate case that's very valuable and they go to somebody who doesn't know how to litigate it and they get 1/10 of the value on their case just because they picked the wrong one. And that sucks. And it's really hard to stomach, but you're going to see a lot more of that if you reduce contingency fees.
How does someone know if their own case is valuable in like the most basic of terms across this industry?
There's a variety of factors, but I think one thing I would say before that in terms of caps on fees is I think part of the reason why people might be a proponent of caps on attorneys' fees is because like civil law, and I think plaintiff personal injury law to an extent, the defense side as well, is kind of a black box. People don't understand what we're doing. Like all that stuff he described with experts, that's just a small piece. Because by the time you get to experts and designating experts, you're on the eve of trial. But by the time that comes around, he's already filed the lawsuit, done written discovery, taken a whole bunch of depositions, done a whole bunch of investigation into liability and damages, talked to collateral witnesses like family members and friends who can talk about what really happened to this person that we're representing. So like, you could say maybe, I spent 100 hours on this case. And then to like the average person, that might sound like a lot, but they also don't know what actually went into that. It's not like we're just sitting back in the office every day on our laurels, filing complaints, and then the money magically comes in. Like we're doing things to create that settlement value or that value at trial that the average person doesn't really know about until they actually get involved in a personal injury case. And then they see it from the inside. So I also think like a lot of the misconception about our industry and then plaintiff personal injury attorneys in particular is that people don't really know what goes into doing it. Like we're putting a lot of blood, sweat, and tears, time, and energy into these files because these people have been so gravely impacted. And it would be like, we would be doing them a disservice if we didn't put this energy into it. And so like at our firm, we have people like Austin and myself and Alan who we know and understand that, as well as the rest of our team, like the rest of the attorneys, the support staff, et cetera. Like they all know that. And that's something that's very important to us. That's something that like we hold a high standard and a high bar when it comes to how we handle our cases. And I think like if more people actually knew and understood what it takes to actually handle and prosecute these cases on the plaintiff side, they might have a different opinion of like what plaintiff personal injury is or whether there should be fee caps.
Yeah, that's a good point.
But then getting back to your question was how does somebody know the value of their case or if their case is valuable?
Because it seems like really, really good plaintiffs attorneys like you guys see this value that, we can, I think, explain to people. And then you realize, literally curate and create that value in court so that people can actually get that value. Otherwise, no one else is going to see that value or maximize on it so that people can actually see that return for themselves. But when something happens, whether that's auto accident, premises liability, whatever it fits under personal injury, like what are things that people should look out for so that they can feel armed with that knowledge?
So the number one thing for me is always the client. What do I mean by that? This is personal injury. It is personal.
Thank you for that soundbite.
Your losses relate to you. In a contract dispute, there are terms of the contract and you have to assess the contract. And the terms of that contract define the value of that case. If you're a real estate lawyer, then the assessments you're going to make on the value of a dispute over the real estate is the value of the real estate. In a personal injury case, fundamentally, the value of the case rests on the individual. And I know we live in a culture where we do acknowledge, thankfully, that every human being has an inherent value. Morally, we recognize that each of us have a certain like sanctity and sacredness about our person, and that's true, and that's to be recognized. But also, when you're dealing with a legal system where the basis of damages is compensatory damages to make you whole, to put you back into the position that you were before the incident occurred, whatever that is, the question is, what was the value of what you had? And what is the value then of what you've lost? So one of the elements of general damages is the loss of enjoyment of life. Sometimes I will talk with a client about what their life was like beforehand, and they don't have a lot to say. If you're sitting at home all day, every day, eating Cheerios and playing video games, and then you get a back injury, and that means that now you're sitting at home on the couch playing video games, okay, you have pain, you have discomfort, but the value of that is going to be very different than somebody who's training for a triathlon.
Right.
That's a different value because of the different lives that are being lived and what's been lost as a result of that. If there's, and I see this most poignantly in wrongful death cases, because in a wrongful death case, the elements that the jury has to put money towards is the loss of love, the loss of guidance, the loss of society. These are relationship elements. And when I have a client who tells me these stories of my mom was my best friend, and we would every time around my birthday, she would take me out to the outlets and she'd say, buy whatever you want. One item is all yours. And frankly, it wasn't about the shirt or the blouse that I would buy. It was spending the entire day with my mom. That was the present. That was the gift. When you have somebody who can tell about real relationships and the value of this person, and that's the value of the case, versus somebody who, you know, their parents were missing, they were gone, they were absent, the relationship wasn't there. So that's where I would always begin, and it's always motivating to me to kind of to kind of do a check on my own life, like if I died, what would the value be? You know, how would that be assessed? And also, like, I want to be active enough in my life to where if I was seriously injured, that would be a real loss. It's kind of a weird way that I think about
like good reminders.
Yeah, exactly.
Your life well.
Or if you lost somebody close to you, which of course, like,
yeah,
no one really wants to think about,
yeah,
right? But because we deal with those cases all the time, like he said, cases where family members pass away and then you're left trying to fill that void. I mean, we had the Navarro case, which we've had that up on socials a little bit. I mean, that was a tough case. Like, the loss of a child is something a parent should never have to deal with, right? And so I think kind of getting back to your question, because your initial question was more so, how does somebody know the value? Like, how does the client know the value of their claim?
Look at your life.
You can look at your life. I think, like, in practical terms, like, we get a lot of calls where people are like, I just got involved in a car collision. Can you help me? So oftentimes those people are most interested in getting their car fixed, right? Like, and then, like, they might have some pain. They don't necessarily know the extent of their pain or their injuries at that point, but they do know, like, something's been taken away from them in terms of their health. Mm-hmm. So I think, like, at the very outset, people believe or know their case has value because some wrong has occurred to them that they were not responsible for. Like, I was driving and I got rear-ended. I was walking down the street. There was this big offset on the sidewalk. I tripped and broke my arm, etc. Sometimes the injuries are, you know, the gravity of the injuries right at the outset. Like, we have workers' comp crossover cases, as we call them, where somebody gets injured on the job, but there's third-party liability. Like, the employer's not responsible. The manufacturer of the machine might be responsible, because in these work comp crossover cases, oftentimes it's people dealing with industrial machines. So in those cases, somebody's jacket might get caught in the machine because the machine doesn't have the proper guard on it. It doesn't have an emergency shutoff switch. And then their jacket gets caught, their entire arm gets ripped off. We've had those cases. We had cases where people's legs have gotten crushed. obviously cases where people have passed away. So in those cases, when you call the attorney, your damages are pretty readily cognizable. Like, you know, the severity and the gravity of your injury. So whether it's that case or a case where I'm just driving down the street and I get rear-ended, when you call up an attorney's office, any question that you have, that attorney or some representative from that office should be able to answer that question. And like, that's a little bit hyperbolic, but the quality of the responses you get from whoever you're talking to at that firm, that should inform your choice, because somebody could call our firm and I could get on the phone with a client and probably like 99.9% of the questions they have, I would be able to answer. Or if I don't know, I would have an idea. I can go find out and come back to them. If you're calling up an attorney's office because something happened to you and you're asking like pointed questions or specific questions and you're not getting like very clear answers, or you're getting like vague or ambiguous answers, that might not be the best fit for you. Like, that firm might not be very well versed in what they're doing, even though they're holding themselves out as a personal injury firm.
Unless the question is, what's my case worth?
That's a great point.
Do you get that question a lot?
Oh yeah, all the time. And it's a question that if you actually get a direct answer, that I would say is a red flag.
Yeah.
If the firm tells you, oh, your case is worth $1 million,
because that does happen.
And all you've told them is what happened to you and what your medical stuff is, that's not responsible. It's just not responsible.
I agree.
Cases can churn on a one little fact. One little thing can radically alter an entire case. So what I always try to say is look, there are facts that tend towards making your case more valuable. There are facts that can make it less valuable, and I don't have all of them, right? That's why we do discovery. So I'm going to get more information, which is going to cause a reevaluation. Based on what you're telling me right now, I can tell you these facts make it more valuable. These facts make it less so.
What a lawyerly answer.
But insurance is oftentimes something that we don't know. Because if somebody's like, oh, I got rear-ended, did you exchange insurance information? Yeah, they had State Farm. That doesn't tell me anything.
Right.
I know that State Farm is better than like Infinity.
Right, but you don't know their
or
coverage.
Mercury a lot of times, but I don't know the actual limits of the policy unless I know it's like a semi-truck. So if it's like JB Hunt or CR England or somebody like that, or Walmart, like a Walmart truck driver, I know they have basically infinite insurance. Or if it's a slip and fall, like in a supermarket, I know they're going to have a commercial policy. But he's 100% right. Like, because a lot of times clients know that something has been done to them and they want to know, how much is my case worth? And it is irresponsible to tell them, oh, based on what you told me, this is a 7-figure case, because you don't know anything about the limits. More than likely, you don't know anything about the full extent of their injuries. If it just happened, let's say a day or two ago, there's a lot of unknowns. But like, if they have specific questions about like, what is how long is this case going to take? That's a common question that we get. And I tell people that's contingent upon how long your treatment takes, hopefully getting you back to where you were before this happened. If we have to file a suit, like there's a variety of factors. And so like, I always tell them it depends on those factors. And I advise them, you should be prepared to be in this for the long haul, because every case that we get, some cases settle in pre-litigation. Sometimes they don't. We have to file suit. And there's we have 2 years to file suit. So if you're treating for 2 years, we don't even know the full extent of your injuries until you're done treating. And we would be doing you a disservice if we tried to resolve the case before we know how badly you've been injured. So I'll tell you right off the bat, I don't want you to have any preconceptions about how long this case is going to take.
So if they're injured for or in treatment for 2 years, do you have to still file within that though? Oh
yeah. So you don't wait to file until all their treatments, because we have clients, a lot of them, I mean, almost all of my clients are going to continue having medical treatment throughout their life. Right. So if you're sitting there waiting until treatment's resolved, you're never going to try the case. But what you can do is try to get an assessment, a comprehensive assessment of what we know to date, with an understanding of what the prognosis is with respect to different parts of the body, and a diagnosis of what has been suffered up to that date. And with that assessment, now medically, okay, now we have a framework for this. Now we can put better numbers to it. Another, aspect of that is the unknown unknowns. Like you sometimes you don't know what you don't know. and then time passes and the case becomes more. There are cases where I thought were, $25,000. This is suddenly tanked for whatever reason, or there's nothing really there. And then I do a little bit more discovery and it turns out, oh, there's actually a ton of liability. Oh, the damages are 5 times worse than I thought they were. So that happens a lot where the case becomes a lot more valuable. Also, sometimes you're in the middle of the case and you think this is a really great case. And then, your client was entirely honest with you about pre-existing stuff. And then that comes out and you're saying, hey, even though that prior issue was unrelated, because you didn't disclose that, now it looks like you're lying. And if it looks like you're lying, that reduces the value of your case. Pure. So I always try to emphasize, you got to tell us everything. It's so much. I can handle, I can put things into perspective. But when you if there was a message, a PSA I would give to future clients, tell us everything. Honestly, there's this habit of oh, I didn't think it was important. Well, it's the same part of your body that you went to the hospital to have treated, 5 years before. I agree. We can probably say that's unrelated. But if you don't disclose it, then it gets used and twisted in precisely the wrong ways. And when you're already battling an uphill set of prejudices on greedy plaintiffs trying to get rich, you got to just be, truthful and straightforward on that kind of stuff. So anyway, so there's all kinds of little things that can radically alter the value of the case that it'd be irresponsible to anticipate ahead of time.
Yeah. I mean, I would say as an ancillary point, because he's right, the type of cases that he's handling, like serious injury cases, catastrophic injury, wrongful death cases, we're filing on those cases immediately most of the time. And the reason being, a lot of times in what we do in pre-litigation, there's a pre-litigation insurance adjuster on the other side of the case. And we're going into that black box that I was talking about earlier. There's a pre-litigation insurance adjuster on the other side representing the defendant who's holding the purse strings with respect to the value of the case. So they get authority for what the case is worth from someone else higher up, and then they just toe the line. Once we file the lawsuit, the case gets out of the hands of the pre-litigation adjuster into the hands of a more seasoned adjuster and also into the hands of a defense attorney. And oftentimes that litigation adjuster and the defense attorney, they know way more about what the potential exposure is, what this case is worth versus the pre-litigation adjuster. So unlike those files, it doesn't make sense to potentially wait for the client to finish treating or something like that to file suit. But because we're a mixed bag of, we're litigating cases and we also have pre-litigation cases, we're not filing on every single case immediately because we might know what the insurance limits are. And we know that based on what the limits are, what the injuries are, there's an opportunity to settle this case for the full value of the limits before we go into litigation. Because we also have to be concerned about the client. Because as he mentioned earlier, in pre-litigation, there's one contingency fee, and in litigation, there's another contingency fee. It goes up because we have to do more work. He has to do a lot more work in litigation. Mm-hmm. So if we can resolve the case in pre-litigation, keep that contingency fee lower, it's beneficial to the client because the client is going to walk away with more money. Mm-hmm. In terms of what cases are worth and the value of the case, it is 100% a function of what's happened to the person. And not even of course, being able to articulate all those things he talked about, in a personal injury case, the measure where somebody lives, not a wrongful death case. It's all those things that he talked about. It's the fact you had to endure mental pain, physical suffering, loss of enjoyment of life, anxiety, humiliation. If you have surgery and you have a scarring and disfigurement, which for a lot of women, it's a lot more important than it is to a lot of guys, especially if you have a visible scar. Because we have cases where women have to have surgery and now they have a visible scar for the rest of their life, right? And it affects you. So those things, in an ideal world, we would be able to turn back time and make it so this never happened, right? But the only form of justice we have is money justice. But oftentimes, what's been taken from you, there is no measure of compensation that you can come up with that adequately compensates you for that. In a lot of ways, money is a cheap substitute and a cheap metric to try to measure what's happened to somebody, especially when you're talking about the loss of a family member. I have a friend who's a trial attorney named Dan, and he would always say, these things are priceless, right? And it doesn't mean that they have no value, it means they have so much value, you can't even put a price on them. Like even somebody who has a physical injury and they have some aspect of their physicality that's been taken away from them that they can never get back. And that happens a lot of times because we have clients that have neck and back surgeries. Like those are two of the most common surgeries that we have and what we deal with, a neck surgery or a back surgery. They might have what's known as a fusion, where you're getting hardware implanted into your body. So if you're just an innocent person who's walking around or driving, something happens to you through no fault of your own, and now your injury is so bad that you have hardware, let's say, in your neck for the rest of your life. And if you have a fusion, that means that now you have less mobility and flexibility in your neck than you used to have. So now, like, instead of me being able to bend my neck back and look up like that, I might have to lean back because now I have a fusion and there's multiple levels in my neck that are fused. So in order to do that same thing, I have to lean back like that. That's something that's been taken away for the rest of my life. And if I have another, let's say 40 years of life expectancy, that's something that I'm dealing with for the rest of those 40 years. So the average person, like, we'll talk about juries for a second. Like if I'm in trial and you're a juror, I can't say, what would that be worth to you? Because that's violating the golden rule. I can't ask the jurors to put themselves in the shoes of my client. But like for purposes of this conversation, imagine if you had something related to your physicality that was taken away from you for the rest of your life expectancy. You can't really put a number on that. Like I can't. And I have things that I deal with to this day through my own injuries, like from weightlifting, playing sports, etc. Like I had a knee surgery and a shoulder surgery, and I had a shoulder surgery in 2015. I had a knee surgery in 2018, and I still deal with those issues to this day. So if you're telling somebody like now they're in that position through no fault of their own, and you have to compensate them for their body not being the same as it was before this incident happened, like that truly is priceless, right? The same with losing a loved one. You lose a son, a father, a mother. There's no amount of money that can replace that person. In fact, you would probably pay any amount of money to just have like 5 seconds with that person, especially because in these cases, people are passing away in just like dramatic, sudden circumstances. And oftentimes the family members didn't even have the opportunity to say goodbye. So there's people out there that would pay any amount of money just to have that opportunity to tell that person who passed away, I love you. Thank you for everything you did for me. I'm sorry you have to go. Right. And so that's really what we do is about. Like to reduce it to these people are just billboard attorneys or ambulance chasers who are making a quick buck is a very unfounded and simplistic reduction in terms of what we do. Like what we do is not that. And we have a lot of peers that what they do is not that. And that's what we're doing on a daily basis. That's what he's doing in the office on a daily basis. That's what me and Alan are doing on a daily basis when we're talking to them about their files and making sure these files are in the best possible position to try to compensate people for something that really can't be compensated. So like for me, that's a lot of what this comes down to. Like these initiatives to cap damages or cap attorneys' fees is like you're doing your own citizenry a disservice by doing so or trying to do so.
So what do we do?
We have to educate people. Like that's part of what we're doing here today is putting this message out here to hopefully educate the populace, because there's that old phrase, each one teach one. So the more like if we can put this out there and then one person watches it and it changes their mind or opens their mind to give them a new perspective, and then they're just talking to their friend, they're like, you know what, I was watching this podcast, it's personal, and they talked about da 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 da, and then now they're out there spreading the message. It's like we turn other people into advocates, right? Like the adage in the Bible where Jesus was like, I could give you a fish or I could teach you to fish. So it's like if we can teach somebody about this and then they can go out and teach other people and we can create quote unquote like other apostles or disciples, then that's what we have to do. But like I think the tagline for the New York Times is democracy dies in darkness, right? And so the Washington Post, yeah. There you go. So it's the same thing. Like these principles and these values that we hold dear, they're going to die in darkness if we're not out there shining a light on what's really going on and potentially educating people so they can educate other people, and then the narrative can change.
To me, a lot of it comes down to being on team human. I never really look at the defendant as like the bad guy or the enemy. That's another human. It's another person. That person is not controlling their defense. It's an insurance company. Now, the insurance company is certainly employed by a bunch of people who, if they were injured, would benefit from everything we're trying to fight for.
Right.
It's the entity that's enslaving them into the nonsense system that they're in that has a single-minded, profit-oriented focus. And what a lot of people don't realize is that a corporation actually has a duty, a legal duty, to optimize profit. This is the problem. This is the problem.
Yeah.
And so, in fact, I think in United Healthcare, after the whole Luigi fiasco, they started to try to change some of their policies to increase the acceptance rates, and they got sued by by the shareholders. So I think that they currently, right now, have an open suit to resolve that.
Oh my God.
Yeah. So the CEOs have a job to do, and it's not to legitimize them or fight for them, but again, like the humans that are caught up in this system.
Yeah, the incentives are broken.
The incentives are totally broken. And so, and that's what radicalized me when I was when I first started working in PI. Is I'm watching these insurance companies control the defense lawyers, control all of the humans to say stop being human, stop looking at the humanity of the other side, do what I say, deny, delay.
Yeah,
that's why they do that. And so the answer is to really try to help team human understand what we're fighting against. Now, I'm not anti-corporations.
right.
The firm is a corporation. Like most corporations in America are small corporations. I think it's over 80%, if not more, that don't actually have profits in excess of $1 million. The overwhelming majority of this is the problem.
Yeah.
And so, in fact, I think in United Healthcare, after the whole Luigi fiasco, they started to try to change some of their policies to increase the acceptance rates, and they got sued by by the shareholders. So I think that they currently, right now, have an open suit to resolve that.
Oh my God.
Yeah. So the CEOs have a job to do, and it's not to legitimize them or fight for them, but again, like the humans that are caught up in this system.
Yeah, the incentives are broken.
The incentives are totally broken. And so, and that's what radicalized me when I was when I first started working in PI. Is I'm watching these insurance companies control the defense lawyers, control all of the humans to say stop being human, stop looking at the humanity of the other side, do what I say, deny, delay.
Yeah,
That's why they do that. And so the answer is to really try to help team human understand what we're fighting against. Now, I'm not anti-corporations.
right.
The firm is a corporation. Like most corporations in America are small corporations. I think it's over 80%, if not more, that don't actually have profits in excess of $1 million. The overwhelming majority of corporations are, a couple employees, an LLC that's, solely owned. That's the overwhelming majority. What we're dealing with are multi-billion-dollar international, multinational corporations that are legally obligated to maximize and optimize profits by internalizing the profits and externalizing the costs. And so the costs are now suffered by all of us. So yeah, we'll internalize the profits and let the toxic waste go into the rivers, and then that cost is incurred by the public that live downstream. We're not internalizing that cost. That helps us maximize profits. That mentality is what we are constantly at war with. And what I see myself is like, that's the war I'm fighting. Every individual that I'm representing is a human being. It's actually one of the main reasons that I left being a prosecutor. I loved representing the people of the state of California, but while I was a prosecutor, I came to realize that the individual victims, I wasn't representing them. I was trying to do my best by them by representing the legal system. But I wasn't representing them. And there are some times where even the victim doesn't want the case to be prosecuted or needs additional help for their own justice. And that's what this is. That's what tort law is. It's the only place where the individual gets their justice. It's not always been the case that that's been available in societies, throughout humanity. So that to me is the framework. Educate, spread the word, that you just, be aware of the fact that this is what's going on. You've got a bunch of very, very well-resourced corporations, insurance companies from all of the giant industries that have a very strong, not just a profit motive, a profit duty that they are executing. It's self-fulfilling, and you gotta stand up against it. In fact, to one point off of that, maybe the proposed legislation to reduce caps is often said, these plaintiffs' lawyers are trying to get too rich. This is about you. This is about you getting paid. Well, a real easy fix to that, if that's what you're interested in, is to promote a statutory policy that plaintiffs get statutory attorney's fees. In employment law, they have that. My wife does employment law. She did employment law for a while.
Yeah.
If you represent somebody who's been harassed at work and suffers an adverse, work condition, and they've been retaliated against, they're unlawfully terminated, the plaintiff's lawyer will represent them, and whether their case is worth $50,000 or $5 million, at the end of that case, you get the verdict, and then you apply for attorney's fees, and the court will then award attorney's fees in addition to that verdict and award. So that way, the consumer is walking away with everything, right?
And then that means that the workplace that did wrong pays for the attorney.
Exactly. How about the one that does the wrong pays the cost? Right. How about that?
So what that would look like in PI is like State Farm pays the $1 million settlement plus
attorney's
fees. Okay.
Yeah.
And those attorney's fees are based on the amount of time that we put in the case and our hourly rate, like he was saying earlier. And then a lot of times in those cases, you also get what's known as a multiplier, because the court says the fact that you took on this case, like he said earlier,
and then created value.
You created value, but also like you had these two cases. You took this one. You could have taken this one, but you took this one. So because you couldn't take this one and put all your resources into taking this case, like it's an opportunity cost loss, like he said. So like you're working on this case, you missed out on other cases or opportunities you could have worked on. So in addition to the hours that you work times your hourly rate, we're giving you a multiplier of like 1.5 or 2 or whatever to reward you for taking this case on contingency and losing out on these opportunity costs of taking these other cases.
And this would be a system that like could functionally replace contingency, I guess.
It wouldn't replace it, but what it would do is it would shift what they're saying is such an unjust situation. And so for example, in employment contracts, there's usually still a contingency fee agreement, 40%, whatever. And what that does is it allows the case to settle. So they don't need to necessarily move for costs from the court. You settle for X amount, and that's just incorporated into the value. So if everyone agrees the case is worth $200,000, but now we're about to get into experts, the defense knows, all right, we got to settle it for more than $200,000 because they're going to get their attorney's fees anyway. So you keep the 40%. And like what I think most firms do is they say in the retainer that it's 40%, we're going to move for our motion. And, we can either take the 40% on the whole recovery, including the statutory fees, or we'll just take the fees. Either way, you're ending up with, your share in essence. So, but you're not going to see these nonprofit organizations trying to put up these contingency fee caps. Oh yeah, let's also add statutory fees. They're not going to do that. They don't do that.
Because that's not actually the purpose of it.
Because it's not the purpose of it. The purpose of it is to actually decrease and diminish and degrade the quality of representation that individuals can have. That's the purpose of it.
This podcast is brought to you by Adamson Ahdoot, LLP. Hosted by Christopher Adamson. Produced by Lauren Henning and Chris Wigan. If you have thoughts or suggestions, email us at itspersonal@aa.law. The views, opinions, and statements expressed by guests on this podcast represent the personal perspectives of the individual speakers and do not constitute official positions of Adamson Ahdoot LLP or its attorneys, staff, or affiliates. Nothing discussed creates an attorney-client relationship, and the content is provided for general informational and educational purposes only. Always consult with a qualified attorney about your specific circumstances.